This conference will now be recorded.
One last question for you, Mark, before we begin. When members want to say they raise an objection to a comment, should we ask them to vocalize their objection, if any, so we can hear it and be sort of taking a straw poll at the time, or should we have that done through the chat feature?
I will leave that in your competent hands. I don't particularly have a preference. I don't know whether there's necessarily a better or worse way to do it. Just kind of play it by ear, I guess, would be my suggestion. But given how much we have to go through today, I think, notwithstanding that we have members joining us by the second, I am going to get going. And with John, unless you object, I'm going to start with taking attendance, getting the meeting in order.
Proceed as you suggested.
Fantastic. All right, I'm going to run down the list. As usual for attendance, once I call your name, please say your name. Please say here, present, whatever works, just to test your mic, among other things. So with that out of the way, John Cooney.
Here.
Boris Burstein. Actually, well, no. Brad Brown. Thank you.
Morning. Good morning.
Toby Dorsey.
Everyone, I see we have looks like Mark Kirsch is on the phone.
Hi, Toby Dorsey's here.
Thanks, Toby. Don Elliott. I saw Don here. I see Don here. Don, can you turn on your mic? Can you hear us? Okay, we'll come back. Josh Jackson.
Josh Jackson here.
Thank you. Kristen Johnson. All right. John Kamensky.
Here.
Thank you. Michael Livermore.
Here.
Thank you. Deirdre Mulligan. Okay. Melissa Natrem. All right. Eno Olson.
Here.
Elizabeth Papez.
Here.
List. Coke Stewart.
Here.
Elham Tabasi. Okay. Steph Tatham.
Hi, this is Steph.
Hey, Steph. And then Anthony Schultz.
Here.
And Jonathan Hill. Oh, hi, John. All right. Are there any members whose names who are here whose names I did not call?
Don Elliott, I got here a little bit late. We were already up to the H's, but I'm here.
Thanks, Don. All right, John. With that,
Nick Pierce, I'm not a member of the committee, but I'm a member of ACUS, or a senior fellow.
appreciate it. Thanks for joining us, Dick. On that note, John, I think you can take it away.
Good morning. Thanks very much for assembling today. We're here to discuss the final stylistic changes to the statement on AI that ACUS has been considering with your substantial help. And once we've had that discussion, we're going to have a vote on approval of the final statement with the stylistic changes as approved by the committee. In the interest of time, today we will limit the comments to actual committee members, consultants, and ACUS members who are not on the committee. To the extent necessary, we will give priority to the actual committee members so that we can move through this document. But before we launch in, the first thing I want to raise is yesterday you should have received a copy of 5 minor stylistic changes that were proposed by the ACUS Council when they reviewed this document. And I'd like to ask Matt if you would like to move their adoption.
I don't know that I don't consider myself a member of the committee, so I'll look to others to do that. There's an accompanying memorandum. Has everybody seen that as well? Yes? Mark, that's been circulated?
Yes, that was circulated as well.
So I would leave it to a member of the committee to I would leave it to a member of the committee to move the amendment.
So moved.
Is there a second?
Second. I'll second.
Thank you. Thank you. I'll now ask if the adoption of the council amendments are satisfactory to the members of the committee. I will handle this by saying if I do not hear any objection, then I will deem that the committee has approved this. Having heard no objections, I will deem that the motion is adopted. All right, then we will proceed next to consideration of the proposed stylistic changes, the document with all the red lines in it that was circulated to you. We essentially had consensus on the substantive points, I believe, in the last meeting. We formed a committee on style at the request of the members of the committee, and the committee on style worked hard last weekend to try to come up with a draft that carried out the intentions that we heard in the last meeting. Since that time, we've had a significant number of stylistic changes that were also submitted in red line format by other members of this committee who were not on the committee on style. Thank you very much for looking this up and taking the time to work on it through your other responsibilities. As I said, the changes are submitted in red lines, and today we were here to consider only the comments in red lines that have been circulated to the group. And again, in the interest of time, I will take the committee through the document. I think paragraph by paragraph is my thought about what will be the most efficient way to work through this. And I will ask if anyone has objections to any of the proposed changes in a particular paragraph. Again, if I don't hear objections, I will state that I consider the changes to have been adopted by the committee. But if the members note their objection, then we'll discuss the matter to which they have objected. My request to everybody is to keep it quick, because as you can see, we have a large number of red line changes. The good news is that most of those are really just stylistic. And I'll ask this committee to do what I did when I was pulling together briefs where there were 5 or 6 law firms involved in the final rewrite, which is, to the extent you can restrain yourself, please, in the interest of getting this completed and getting to the vote today, don't raise every objection you might have to the language. If there are things that are close enough for government work, let's let those go through. And with that, by way of introduction, I'll ask the group to turn to page 1, the proposed stylistic changes that were circulated to you. And I'll ask if anyone has any objections to the proposed changes that are found in paragraph 1, lines 1 through 6. And I think you should articulate those verbally rather than using the chat feature, so that we understand if there is something that we need to discuss in this chapter. So anybody with an objection, please raise that for the other members of the committee. I think that that's probably long enough. What I think then is that one thing I do want to call out and make certain we're okay with this is footnote 1 on line 2, which proposes a definition of AI. There was a definition, a general definition in there from NIST. A suggestion has been made by Jonathan Hill, I believe, to have a different proposal for the definition of artificial intelligence. Does anybody on the committee wish to be heard about which of these 2 alternatives they prefer? Hearing no comments, I'll say that.
It's Don. I'm not able to get onto the chat, and I do have a comment or a suggestion.
All right, fire away. In my vision, both of these are sort of equally general, and I think they're equally good, and either would serve. But that's a very rough approximation. Don, why don't you proceed with something that's better?
I agree with you, John. And my suggestion is that we say something along the lines of artificial intelligence is difficult to define, and there are several competing definitions, and cite at least two of them and maybe a third. I don't think that it's necessary or desirable for this committee to choose among them. So why don't we just indicate the range of different definitions that authoritative bodies have adopted?
Does anyone else on the committee wish to comment on Don's suggestion?
This is Steph Tatham for Jonathan Hill. We're comfortable with that suggestion. I think the point that we were just trying to make is that there isn't a universally accepted definition, and we were concerned if we adopted a specific definition that it might become quickly outdated. So we'd be comfortable keeping the NIST definition, but then going on to say that, there isn't a universally accepted definition or whatever specific language Don would like to propose.
Thank you. Does anybody else wish to be heard now that we've heard I can characterize that as the OMB response? Then it seems to me that we have the consensus of the group here on that. Mark, do you have, this is something that we will have to take care of with a committee on style, if you will, when you actually put pen to paper. Do you have what you need in order to implement Don's suggestion?
I suppose the only question I'd ask of Don in particular is, Don, do you think your concern about there being no single accepted definition of AI is captured fully by the OMB edit, the red line? Or are you suggesting specifically that we give, we expressly identify, one or two, multiple definitions and say we're not choosing among them?
Well, I prefer the approach of having multiple definitions and not choosing among them.
Okay.
But I could also, I could also live with the other approach. I think if we are going to say there is no universally accepted definition, and et cetera, we should probably at least cite to the other competing definitions, so we don't implicitly seem to be favoring one as opposed to the others. But I don't have a particular preference for one definition as opposed to the other.
Unless I hear objections to what Don just said, Mark will deem that to be an approved stylistic modification of the paper.
This is Catherine Sharkey. I just had a quick question. It sort of relates to this point, but Mark circulated to everyone the newest executive order on promoting the use and trustworthy artificial intelligence in the federal government. And I'm just wondering if we are proposing to at least reference that executive order in this, because it does seem like there's quite a bit of overlap. And then as it relates to this point, I read it rather quickly, but they don't try to define artificial intelligence, but they likewise allude to other governmental efforts, I think including NIST. So it does seem like it would be odd for us to be kind of acting with blinders, I think, with respect to that executive order.
So Kathy, this is David Engstrom. They actually do define it. It's way down at the bottom, though. I think it's in, if memory serves, it's in section 9, and it's a fairly expansive definition. And that means that perhaps we should consider some sort of a direct linking to that. At least if we're going to talk about different alternatives that are available, it might make sense to list that one.
Yeah, so that's what I meant. In section 9, they allude to things like section 238G of the National Defense Authorization Act, yada, yada, yada. So one thing could be just, instead of trying here to define AI, we actually can just reference, that's why I raised the question here, to reference our effort sort of in connection with our awareness of this executive order.
Let me ask Don, would you be comfortable with something that simply references the several of these items without quoting them, or do you think that at least one needs to be quoted, or would you be content if we just say there are multiple possible definitions that are used in the sphere and 3 of them?
Well, I don't care. I think the easiest thing to do is simply cite the executive order where we say there's no universally accepted definition of artificial intelligence, and then include maybe as an intermediate, hyperlink to it. So anybody who wants it can get it on the internet. But I think if it's lengthy, we don't have to quote all these different definitions. But we should make them available to the reader, and cite them, but also include hyperlinks.
That sounds like a good resolution of this issue to me. Does anyone object to that approach? This will be the last call. If there are no objections, then we'll deem Don's suggestion approved, and we'll move on to the next paragraph. Hearing no objections, in my opinion, we have consensus. So Mark, if you could take it from there and implement in the final version. Thank you. Let's now turn to paragraph 2, lines 7 through 13. I think a significant number of the red lines here are council decisions. They're council changes that we've adopted. I don't think we need to go back through those, but I'll ask anybody if there's anything in this short paragraph that they think warrants discussion. Hearing no comments, I think my conclusion is that there's consensus behind the paragraph as currently drafted, and I consider the paragraph with the council changes adopted.
John?
Who do we have?
At least one comment. Sorry, but
please proceed.
This is Elham Tabassi from NIS. It's a very minor editorial comment to add and continuous monitoring in line 9 right after procedures for their use. So the sentence reads, when adopting or modifying AI systems and developing practices and procedures for their use, and continuous monitoring. Continuous monitoring links back to the sections on bias, privacy, and security as well. Just for your consideration.
Does anybody wish to comment on the suggestion?
This is Anthony from DOJ. I think that's a good suggestion. I think it covers a lot of the rest of the document in a helpful way.
Any further comments on this paragraph and on this particular proposal? Hearing none, I think we have consensus, and I deem the changes adopted. I'd like to make one short point, which is we really do need to stick to the red lines that have been submitted today, but we also want to make the document as strong as we can and have the consent of the members to it. So this is an example of the situation which, exercising my discretion, this sounds like a useful and not very extensive change that did not require extensive discussion. So I'm happy to hear this, but I do want to remind the members of the committee that we're here to review the red lines today, and we have a pretty good ways to go. So please bear with me on this, but we do need to take a hard line if there is something substantive that would require a lot of debate that was not submitted in advance. Hopefully there are none of those. Let's go on to the next paragraph, lines 14 through 23. And on this, I'd like to make an opening comment, which is typically in the way ACUS handles documents like this, we don't have an introductory statement like we do here on lines 14 to 16, where we list each of the chapter topics that we'll go through. You see that a lot in law review articles, but it's not typical in the way ACUS does this. And I would, I don't think that there's any reason that we need to have that language here, and I would propose to strike it. Does anybody wish to be heard for maintaining the list of 9 chapter topics? Hearing none, I'll deem that we have consensus on that point, so that the opening sentence in lines 14 to 16 is deemed stricken. So let's pick up at the end of 16 and go through the rest of the paragraph. Does anybody have a comment that they wish to raise on the proposed red line changes?
I would just add that we might now need to add the "and continuous monitoring" phrase as well to the last sentence that DOJ proposed adding after practices and procedures for use and continuous monitoring of AI technologies. Mark, I think I would put it after "for use" before "of AI technologies," just to make it consistent. Thanks.
Does anybody else wish to discuss the proposal further?
Can I make one comment?
Yes, go ahead, Kerry.
I wonder, and I'm sorry I didn't think about this earlier, but I wonder about the adjective continuous monitoring, which suggests that every second of every day there is ongoing monitoring. Does that strike anybody as a concern about that particular phrase? Would it be better to say ongoing monitoring in any places where we are dealing with monitoring, so that it doesn't imply that there has to be 24/7 monitoring?
Does anybody wish to be heard on the proposed revision of the adjective?
Or regular monitoring, yes.
Yeah, I made the suggestion of continuous monitoring. That's a term of art. That's what the AI community use. I put regular monitoring in the chat if that's better.
Kerry, how do you feel about that in response to that comment?
That's perfectly fine too, and I do recognize it is a term of art. Sometimes it's also referred to as continuous improvement, but it is not really intended to be 24/7. I just would worry that ACUS's statement could be construed that way. So I think regular monitoring is absolutely fine.
Anyone else want to be heard on this point?
Deirdre is suggesting another alternative, which could be to keep the term of art, but drop a footnote to explain that by that ACUS means not 24/7, but just regular monitoring.
I think regular monitoring is good, and that's fine.
All right, so the matter before the House now is the adoption of regular monitoring. I'll ask if there are any objections to that, and if not, we'll move on. Hearing no objection, I'll deem regular monitoring to have been a consensus choice of the committee, and we'll move on. That change is adopted. So if there are no more comments on paragraph 14 through 23, we'll move on into the transparency section and start with the lead paragraph 25 through 32. Are there any comments on the proposed red line changes to this paragraph? Hearing none, I'll deem the red line changes to this paragraph to have been adopted. Move on to the next short paragraph on page 3, lines 33 through 35. And the same question. Excuse me, there are no changes to this paragraph. We'll move on to the next one, lines 36 to 43, and I'll ask if there are any objections to the minor red lines proposed here. Hearing no objections, I consider these changes to have been adopted by the committee. You'll be tired of my saying this, I hope, by the time that the meeting is over today, but the paragraph 44 to 49, are there any objections to the proposed red line change suggested by Justice to this paragraph? Hearing no objections, I will state that I consider this change to have been adopted. Now we'll be on the paragraph on page 50, line 50 to 58, 59. I believe that there probably will be some comments here. We do have a couple of minor word changes, but we also have a proposal from Dick Pierce for addition of a sentence at the end of this paragraph. And first, why don't I go through the mechanical part of this and ask if anyone has objection to the minor edit that's been suggested. Hearing no objections, I deem that change to have been adopted as well. Who wishes, if anyone wishes to be heard on the proposal by Dick Pierce to add this sentence? Hearing no objections, I'll go back through this one more time because this is one of the more significant changes in the document. Does anybody wish to be heard on this, or can we move on into harmful bias? Going once, twice?
Can I speak? This is Elham Tabasi. I just want to say that this might be a very strong constraint because it should not enter into contract unless they know the AI, and agencies are already struggling by having an AI ready workforce and people experts enough to understand all this. So that's just that's a caution. I don't think we need to, I don't know if you want to change it or not, but it might be a big constraint on agencies. That's it.
Is there a specific suggestion that you have as to how the constraint might be taken out of this, but still maintain the point that Mr. Pierce is trying to make?
I think we can probably find a replacement for should not and use an agency should consider or should take into consideration that when entering in a contract, there are enough expertise within agency to understand that. So a little bit of rewording of changing should to strongly encourage or consider, something like that.
I actually disagree with that. I think that changes the focus. This focus of this sentence is not on people having expertise. It's on people having access to the information about the system so that you're not blocked out. And that's key to being able to do your continuous monitoring and everything else dealing with this system. So I can't imagine why anyone would enter into a contract it would be malpractice if you entered into a contract that you did not have access for the information that you needed to conduct your continuous monitoring. And that's separate and apart from whether you have the ability to do that. So I wouldn't change it.
Dick, do you wish to be heard?
Sure, I can give you a brief explanation here in terms of adequacy is of course the key here, but adequacy to me is already nicely defined by your description of context in lines 29 to 39 that in some contexts you need some disclosure, in other contexts you need less disclosure. So I think you've already addressed that, but in some very important context, the basic principle here is there can never be a decision that has an adverse effect on someone based on secret law. There's a big body of cases under the APA to that effect in some contexts, and a big body of cases under the Due Process Clause in other contexts. So, it varies by context, but I think it would be a really bad idea for any contracting officer to enter into a contract without having a high degree of confidence that the contract permits disclosure to the extent that is adequate in the circumstances. I have to say, it had not occurred to me until recently that there'd be a concern that people within the agency, that the decision makers themselves would not have access. But I was shocked to read this nice piece in Yale Journal of Law and Technology in which agency heads say, well, we don't know what is within this because we've been told that we aren't allowed to have access to it. Now, I don't know how the hell you enter into a contract without the agency having access, but that is being done on the state level a fair amount, and it's going to take years to sort all of this out in litigation. But the result in many cases is going to be that the use of the AI is impermissible because of inadequate disclosure, inadequate notice.
Dick, while you were talking, Carrie Coronese suggested a possible change in the text to sort of bridge the gap here. Carrie, could you explain your approach here?
Yes, I think what I'm hearing is a little bit of a concern about imposing some kind of extra obligation on the agency when with the language of should that seems almost absolute or to connote some kind of additional legal duty. So I just have tried to soften it a little bit to say that the agency, first of all, should avoid entering into a contract. So it's not absolute, should not enter it, but should avoid it. And instead of saying unless it is confident, which implies some, I don't know what level of confidence that really means. So I just suggested maybe saying unless it has taken into consideration how then the people inside and outside the agency who need access to the information will have adequate access to it. And I've put that in the chat function.
Okay. And Michael Livermore also has a comment in the chat section. Michael, would you like to be heard?
Yes. So I guess I just feel like this language, the people inside the agency and outside the agency who need access to information about the system is like very ambiguous. Like, what does it mean to need to have access? So the language that I was proposing just would try to, building off of what Carrie wrote, take into consideration kind of information needs and access to relevant information. Is that me?
Dick, can you mute your mic?
Somebody needs to mute. Okay. to just, I don't know, just straighten up that language a little bit. It's partially stylistic, but I think the way it reads right now is just kind of ambiguous and vague.
Dick, are you able to hear me now? There was some static on the line there previously. Dick, can you hear us? If you could indicate with your hand at a minimum. Michael, could you try again and speak to see if we can isolate the source
Sure.
of the?
Yep. I think there might be some feedback on Dick's system.
It does look like the feedback's on Dick's line.
Yeah, and Mark, while you're at that, I would just, people inside the agency and outside the agency, maybe just use some slightly different language there, just kind of stakeholders, internal or external to the agency or something like that. Or interested parties or some other more bureaucratic speak.
I think ACUS often prefers interested persons.
But guys, it's also the external isn't just stakeholders or interested persons, right? It's courts, it's all of the governmental entities we reference in oversight. So I wouldn't limit it in that fashion.
Maybe actors or something like that, just like something very broad.
We're in an awkward position here in that the proponent of the change seems to be cut off from the discussion at this point. Mark, I wonder if I could ask you to summarize as best you can for the group what you think is before the group now. There's what's the original proposal and where do we stand in the proposed alternative to that? And I guess the best we can do is to try to have you put that on the screen and then to have Dick respond in the chat feature as to what he thinks of the proposal.
Sure. I'm trying to incorporate Mike's edit. Mike, as I understand your edit, it's to add taken into consideration information needs and access to information, both internal and external to the agency. In which case, would I simply delete everything here?
Yeah, that's right. So something like, unless it has taken into consideration information needs and access to information by actors, both internal and external to the agency or something like that.
Okay.
And then stop there. That would be my proposal.
So, John, in answer to your question, the sentence is revised and redline up now on the screen is what I understand to be before the committee.
Mark, could you just retype because it's not coming up as a red line? What the original Dick Pierce comment?
I can put Dick's original language in the chat function if that's useful.
That would probably be faster at this point.
Oh, I'm sorry. There's this where it's an agency should not enter into a contract. Sorry, I'm just cutting and pasting from the earlier document.
I think in the interim, Dick has logged off and it looks as if he's logged back on. So when we have something up on the screen that it's appropriate for Dick to respond to, could you signal us, Mark, that you have that?
Sure. So what we have right now is, I think, appropriate for Dick to respond to. Mike has kindly put the text of Dick's original amendment in the chat feature for comparison purposes. And so
do we want to move on to further changes and then come back to this when Dick is?
I can. Unfortunately, I lost the sound when other people were speaking, but I can tell you why I prefer my original language. by the time there's going to be court opinions, if it's not adequate, there's going to be court opinions that so hold under any number of statutes as well as due process in a variety of contexts. And by the time you get the first of those, you may have 500 or 1,000 decisions that are then invalid. So you better have a very high confidence that the disclosure provisions are adequate to comply with due process and the APA and all the other sources of the duty to provide notice of the criteria that are being used in any decision-making context, or you'll pay a very, very high price 2, 3, 4 years later when you get a court that says, oh yeah, everything you've done the last 3 years is now null and void, start over.
There seems to be a division within members of the committee on this. We may need to take a vote on this if we're not able to come up with language. Mark, I'm having a hard time reading what's on in this smaller type. Do we have an alternative to Dick's original proposal that's before the House now that could be put forward as a alternative if we need to have a vote?
Yes. So the alternative to Dick's language reads, an agency should avoid entering into a contract to use a proprietary AI system unless it has taken into consideration information needs and access to information by actors both internal and external to the agency.
So to my mind, there are two questions here. One is there's two parts to the statement that I think there might be some disagreement about. One is the take into consideration versus, is confident that part of so kind of the strength of the statement. And then there's the characterization of what it is they're confident about. So I don't know if we want to divide those into two different, if we're going to be voting, we might want to, we might not want to conflate those. I don't have an opinion on the confidence versus take into consideration for what it's worth. I'm more interested in what we're confident about and what we're asking agencies to be confident about, which I think we should be clear.
Who else wishes to be heard on the subject of what this sentence should say?
Yeah, I just have a quick comment back to Mike, because I guess I think that Dick's proposal that included this adequate access was good and important. And I think that I don't know if you'd call that a third component, but that's lost in the very vague statement that's now. I find the statement put forward, the alternative, more vague. So perhaps
I guess really the only thing I'm objecting to is the people inside the agency and outside the agency who need access to information about the system have adequate access. That's really that's the part of the statement that I am, and it's not the adequate part. Adequate is fine. It's just the characterization, the people inside the agency and outside the agency who need access to information about the system. That's the part that I'm not in love with, for what it's worth.
Let me stop us there and ask if Dick has any objection to that, the minor modification you just described.
Guess I'm not clear on what it would be involved. Would we just delete?
It'd be something like actors internal or external to the agency have access to appropriate information or something like that, just to something like that.
I don't have any problem with that alternative wording.
Do you have that, Michael? And do you want to put that back up on put that on the screen?
Sure, I'll put something in.
So we can give Dick something tangible to look at.
Just post something. Actors or something. Because I think adequate covers that. Shit. Sorry, I was bouncing. Actors, both internal and external to the agency, have adequate access to information about the system. More adequate covers, you know, the territory, the normative territory, I think, that we're trying to cover.
Okay, so this is what we have now. I'm going to shift to a simple markup so everyone can see what it looks like without the red line chaos.
Yeah, I think Michael's language is better than mine, so I'm fine with that.
Can I just raise one issue for the group on this from DOJ's perspective?
Go ahead.
I'm just curious for thoughts of the group about whether this puts us in a bad place for something that I've raised before as like embedded AI technologies like Siri or things like that, or word processing, where the agency doesn't really know how they work or need to know how they work because they're not like decisional AI that affects people's rights directly. Is this hurting the agency's ability to contract for technologies that have AI in them that we really don't need to know about, or does adequate cover that? Adequate is doing a lot of work there, but we might consider maybe adding something at the end, like given the specific circumstances of the AI system or something like that, just to make that clear. But I think adequate might cover it. It's just doing a lot of work, and I'm curious for the group's thoughts on that. Sorry to be so open-ended, but it's new language.
Michael?
I think it's covered by adequate, but if we put in another clause, you know, kind of given the, you know, the context or something like that, that doesn't seem harmful to me.
Adequacy suffices. We've done it. Our Deirdre's now added this comment too. It seems consistent with the ways that we framed other caveats. Having worked on a lot of ACUS things, there can be diminishing returns to caveats, et cetera. I think adequate's a good word.
Yeah, I don't disagree. I just wanted to make sure we were considering that. I think adequate handles it.
All right, I think we've wrapped up that. So go ahead, whoever was speaking.
Yeah. Do you need the word will in front of have in what's showing there? It's confident that people will have.
I think that's a useful point.
And I'm sorry, somehow I know actors got changed to people, but our courts, we consider courts people. It just, again, it should be consistent with our oversight about internal and external oversight.
Last I checked, judges are people too.
Yeah, we can cite Joseph Raz. He wrote a great article.
Right. But AI systems that are external to the agency might need access to information about the AI systems. So.
So Mark, what do we have on the screen now on lines 49 to 51?
Have what I understand to be it sounds like a consensus, but I'll leave it to you to decide whether there is consensus, whether to take a vote. But this reflects all of the inputs so far, minus the fact that there may be some continuing dispute about actors versus people. But otherwise,
All right, thank you. Dick, I'll turn back to you then and ask your views as to the sentence as modified.
Yeah, I think it does everything I think needs to be done.
All right, then I'll step back from this and ask if anybody has an objection to the Dick's proposal as modified by the red line. It's not red line, but the phrase as it now appears on the screen. Does anybody have any objections to that? And if you have minor wording edits to suggest, let's hold on to those. The question here is about the concept, the big concept of whether to accept the sentence. Hearing no objections, unless I do, in the next few seconds, I'll deem that there is a consensus to adopt this sentence, subject to the possibility of minor stylistic changes to come. In hearing no objections, I consider the change to have been adopted. Now, does anybody else have, before we leave this, and we do need to leave it and move on, does anybody have a final minor stylistic change they want to suggest? Hearing none, I think we have consensus here, and so we'll consider the sentence as it now appears on the screen to have been adopted. And we'll move on into the harmful bias section and start with the paragraph, page 4, lines 60 to 68, and ask the question whether anyone wishes to be heard with an objection to any of the red line edits, the true red line edits that have been added to this paragraph. Hearing no objections, I'll deem these changes to have been adopted. Same question for the next paragraph, 66. I'm sorry, I've got a slightly different setup here. Oh yeah, it was the old. Yeah, I'm going to have to work off the screen if you'll excuse me. For the paragraph that begins AI systems, which was the former line 69 to 74 and is now 66 to 71, does anyone have objections to the simple red line that was put in here? Hearing no objections, this paragraph is modified as deemed adopted. Going on to the next one, paragraph 72, line 72 to 77, the former line 75 through 80. Does anybody wish to discuss the red line proposals put forth here? I have a question about this one, which is I'm wondering about reflect new external data in circumstances. I'm wondering if that doesn't sort of put us on where we have to be on a continuous response mechanism to this. Were the people who suggested this, if they could speak about what was intended by reflect new external data in circumstances? Something that goes beyond sufficiently current.
Hi, this is Elizabeth Pepez. You know, I don't feel strongly about this change. The one thing that occurred to me, and we hit this a little bit at the end of the statement, but you know, everything in agency practice takes time. And, you know, I think there's a real concern that, and it made me think of it Mark and I were talking about, there was a Wall Street Journal article recently about, during the pandemic, bots grading student homework. And school districts invested a lot of money in setting up these auto grading programs for the teachers. And then, several months into it, they started realizing that some of these things were sort of overly stringent in the sense that a child would get an answer right, but would be graded wrong because they capitalized a letter. And the bot was so focused on whether each letter, adhered to the teacher's answer key that they were getting a 0 credit for the absolutely substantively right answer because there was a capital or something. And in looking at this piece, I'm not wedded to the language, or if we want to pare it down for this draft, I'm fine with it. But one thing that occurs to me is, in the agency setting, it takes a long time to procure and to set up a system and to get it going and to put in the inputs. And then, what happens if you have a situation analogous to the educational setting where you start getting feedback of, hey, wait a second, we're getting people calling on the phone, or, teachers are looking at these exams and going, how did this child get a 0? I know they studied. And you realize there's a problem. And that's the kind of that's kind of the easiest example that popped to mind when I was looking at this, of you've got to have some rigor or protocol for revisiting the AI algos or the scripts so that you're not just, perpetuating error. And that's all I meant by it. If there's better language, or if we want to pare it back, I'm fine. But I do think that's going to be a major issue, sort of on the ground if agencies, continue to make use of these systems.
Right. For people who haven't looked at the chat feature recently, Carrie Colonnese has up on as the last item there, something that I think of as a friendly amendment to try to rephrase this using new information and circumstances. So Elizabeth, I guess I should ask you directly whether you think that that's an appropriate resolution of the comment about what language should be included here.
I think that would be fine.
I see Michael Livermore has a comment up. Michael, would you express what you're trying to get at in your chat feature?
Sure. So this is just the earlier where we edit on the kind of continuous versus regular update, and we were with regular. That seems to be to go to this point. The location of the proposed sentence here, recall that we're in the bias section. And so if we want to kind of reiterate the point about regular updating, we just might want to do so in light of a particular bias concern rather than a more general concern about regular updating of the algorithms, which I think is dealt with in the earlier revision.
So would you have a change to the language that's now on the screen?
Well, I guess I would just ask the folks who proposed it whether they think the earlier edit that we made, urging agencies to regularly, monitor the performance of the algorithms, is sufficient to address the concern that they entered in, that they're kind of proposing here.
Elizabeth?
I'm very sorry. I had to respond to an email. I'm sorry. What was the proposal?
So the question is whether the earlier edit that we made in the course of this conversation, where we urged agencies to engage in continuous, and then revise that to regular monitoring of their AI systems, is sufficient to address the concern that you're raising here.
Yeah, it is. I mean, I this was a little more specific, but again, I'm not wedded to it. If you want to cut it here, I think we also had, a similar point in the last section of the statement, so that it's fine.
Nina seems to have just posted a chat feed that has a different perspective. Nina, would you like to be heard?
Well, I just think that I realize we're all concerned about length, but I think this is specific to harmful bias. And I took the reference, I saw this as a very positive reminder that that in the context of operation, biases may appear that are not clear at the beginning, or they may appear because of, I was responding to external data or circumstances. So I thought it was specific to harmful bias, and I thought it was a good reminder for people.
Does anybody else on the committee wish to be heard on this point? If we're just fighting about the addition of a few words here, I don't know that it's worth the committee's time to spend much more effort on this, because we do have some substantive issues that are coming up. So can we get a sense from the people who have not spoken in this, whether they have concerns about adding the additional words or not, to try to reiterate the concern here in the specific context of bias, or whether we should just make the assumption that the use of regular in the prior paragraphs is sufficient.
I am a big believer of regular and continuous monitoring and evaluations during the operation. So I think adding it here doesn't harm anything, but you may want to also consider, if you add it for bias is really important, but it's also important at the security and privacy, because system can get more vulnerable by time. But I think keeping it here is good. I was just going to, I don't know if you like it or not, but for the simplicity, make a little bit edit that they remain sufficiently current and relevant to the functions that they perform. But if you want to emphasize, get that out, because technically I don't understand what circumstances mean. But I don't think it has any harm by keeping it here.
All right, please make a note and bring that up when we get to Chapter 7 on security. But let's deal with what we have here now. Does anybody have an objection if we were to adopt the language as it now appears on the screen with the 3 words in blue? But I actually, my eyes are not sufficiently good. I can't tell if part of that has been stricken. So, Mark, can you do me a favor and read what you have on the screen that would be the subject?
The only changes, we're striking external data. We're replacing it with information at this point.
All right. Does anybody have any objection to this? It seems fine to me, and I'd like to move on. Hearing no objections, I consider the change that Mark just described to have been adopted. So let's keep going. Because I think we have an issue here in the next paragraph, the one that begins on line 78. But I was concerned about the phrase on, let's see, which line is it in? It's in line 80 about adequately trained personnel. I don't know if that's a term of art or if it's suggesting some group, a trained group of personnel, as opposed to some other suggestion, because I wonder if training is restrictive. Does anybody have a view on whether there's a better way to phrase the thought that we want to make certain that, or how to define the processes here that assure that, or adequately assure that there can be proper inspection of the AI systems and decisions?
My concern was not so much, I thought that referencing people having the skills or abilities to actually do an intelligent review was a very good addition. I was concerned about eliminating the diverse perspective language. And I'm wondering whether we just say that skilled personnel that reflect diverse perspectives are able to inspect AI systems. So by, skilled sort of picks up the adequately trained, but you're also bringing back in the fact that we don't want just, when we cite this later on, we just don't want technology people. We want legal, policy, internal ombudsman, et cetera, to be able to look at this. But they need to be skilled. They just can't be random.
That addresses my concern in the traditional ACUS way of making a broader statement, because I was worried about the restrictions from trained and what that might entail. But I'm not close to AI. Does anybody else who is close to AI wish to be heard on this point?
Could I just say one thing? The use of the term diverse, we often think about diversity as tied to protected attributes. Obviously, it's been broadened through lots of kind of managerial laundering, but I think that it would make sense here to talk about different kinds of skills or and stakeholders or some other language, because in the AI community, there are people who are very focused on demographic diversity, and I don't think that's what you're speaking to. So I would be careful because of some of the cross-discipline uses of those terms.
Can I chime in real quick, because DOJ proposed that edit? That was exactly our concern as well. We didn't know how exactly an agency would have to go about this. Does this mean people from outside the agency? Is it demographically diverse? So that the diverse language is the part that we were concerned about. I'm not wedded to trained versus skilled. I think that's totally fine. I think we just need a better way to say diverse without saying diverse potentially.
I have no problems with people changing the word diverse as long as it makes clear that you're not limiting it to technologists. And that's always a problem when you use words like skilled. The focus is on not that you have legal skills or that, that we want them to understand systems, but we also want to bring in all these different actors within an agency. And I don't know whether you want to go external to the agency in the context of reviewing the system.
I agree with you 110%, and you could use the word domain experts and technical experts, because I think domain kind of emphasizes what you're interested in there.
Can I speak in favor of diverse? I think that its vagueness is actually an attribute here. We can, it could mean demographic diversity. We could mean, disciplinary diversity. We could mean, diverse stakeholders. I actually think that's a good thing, where we don't have to. This is obviously a highly controversial area, and lots of people are going to have disagreements. Instead of now trying to nail that down here, because I don't think we want to preclude the idea that some notion of I don't know, demographic diversity would be the idea that I want to exactly endorse, but some a broader group of people than who might be traditionally in the room would be a good thing. So in any case, that would be, I think, an argument in favor of keeping the diverse language.
So maybe diverse disciplines rather than diverse perspectives or something that sort of narrows it down. And Carrie's got a suggestion.
Yeah, Carrie is a master of finding consensus on these things. Carrie, could you speak on behalf of your suggestion here?
I was just trying to sort of eliminate the word diverse, but nevertheless infuse a little bit of ambiguity along the lines that Michael was trying to speak up for, and just say, skilled personnel that reflect various disciplinary and other perspectives, or other, even say, relevant perspectives, if you'd like.
How do people feel about Carrie's proposal?
So it seems okay to me.
My question is, what is a disciplinary perspective and what isn't, that makes that grammatically right? I agree with where you're getting at. I'm just trying to think through the actual words.
Well, a perspective from a lawyer is going to be different than a perspective from a data scientist. Right.
Could we just say that reflect various disciplines and other relevant perspectives? Does that work?
Sure, you could do that. Yeah, you could do that too. Yeah.
Anthony, I need you to repeat that change.
So various disciplines and other relevant perspectives.
You strike other in that case then, that reflect various disciplines and relevant perspectives. Does that get?
Sure.
Yeah, I don't think other you need anymore.
I think that's great.
Mm-hmm.
All right. How do people feel about this? We still have to go back and have a vote on the entire paragraph. because there were some other relatively minor red lines in it. But let's focus on this one first before we go to adoption of the whole paragraph. Does anybody have any objections to the revisions to this sentence as set forth in blue on the screen?
I would just ask whether if we could just delete the word skilled, because I think to avoid the issue of limiting to technical people, also personnel at agencies are skilled because they're agency personnel. So I don't think we need to have a subset of skilled personnel versus unskilled personnel. So I don't think we need skilled anymore, unless others disagree with that.
All right. That sounds like a friendly amendment to me. Does anybody have any objections to it? Hearing none, then I'd propose to move to the broader question about whether anyone has objections to this paragraph with the revisions set forth in the red lines and the revisions that are now set forth in blue on the screen. Any objections? Hearing no objections, I deem that these changes have been adopted, and now we're free to move on to technical capacity, topic 3. I hope we can run through these pretty quickly here. We're in a couple of pages here where there are some red lines, but they're very minute. We start with the paragraph lines 87 to 92. Does anyone have any objections to the red line suggestions here? Hearing no objections, they're deemed adopted. Same question, the next paragraph, lines 93 through 100. Does anyone have any objections to the proposed red line changes? Hearing no objections, these changes are deemed adopted. Now we're ready to move into topic 4, obtaining AI systems, starting with paragraph that runs from 102 to 109. Does anybody have any objections to these proposed red line changes? Hearing no objections, these changes are deemed adopted. I should specify that in some of these areas, the redlinings include additions of footnotes. I'll pause here on this one and go back and ask specifically if anyone has any objection to the footnote 6 that would be added, the two-line footnote. Hearing no objections, the footnote is deemed adopted. So now we're into the paragraph that lines 110 through 114, and this, footnote 7 is something that was there previously, so I'll ask if anybody has objections to the red lines that are just in the text of 110 to 114.
How about a compliment? I think it's a great addition.
All right, hearing no objections, these changes are deemed adopted. Now we're in number 5, data. I'll ask for whether there are any objections either to the text of this paragraph 116 to 122 as adopted and to footnote 8, which is included within this. Does anyone have any objections to either the text or footnote 8?
So if I can object to my own edits, I think that we included the footnote to kind of elucidate what we're getting at, but I don't think we need footnote 8 to actually make it into the final version because it's kind of specific. I think that the text of the added textual sentence gets far enough. So a friendly edit to our own friendly edit is to delete footnote 8 unless there's objections to someone that really liked it.
Any objections? Having heard no objections, this language is considered adopted with the deletion of the footnote. And I'm good.
Can I bring up and I apologize for that, a nitpicking for harmonization of the document. I noticed that so far, every time that the sentence starts with an agency has been changed to agencies. On the first line of the section, it says an agency should consider, just for harmonization, and I really apologize for that. Maybe you want to consider agencies. That comes from many years sitting in standard committees. I apologize for that. So line 116. Yeah.
And we'd have to make the same change. No, I'm sorry. The language on 120 to 122 seems fine. It's just changing an agency in line 116 to agencies. Any objections to that proposal?
No, I think Mark's got it. I think this is probably like a global change that we're going to have to go through at the end for the style committee, but I think that's a good change.
All right, we'll revive the committee on style at the end of the day today to go through and proofread for changes like this. I want everybody to be aware of that. But this is the classic thing that's within the ambit of a committee on style. Okay, so the committee on style has that. Now we're in number 6 on privacy, and I think I saw that Steph had to leave. Is there anyone here who would know Steph's point of view on this issue?
John, this is Matt. It appears from the chat that Steph has given her sent it to the recommendation, so I would assume that she's on board.
All right. Thank you very much, Matt. That's good to know. So let's launch in. Does anybody have any objections to what's in paragraph 6? I'm sorry, section 6 on privacy.
If I may, I have a simple edit at the last sentence that it says OMB and NIST has developed risk management frameworks, a risk management framework for agencies in utilizing, I can't see, I changed it. Can I read it here? A risk management framework for agencies to utilize in implementation of AI systems. So at least from the NIST point, we haven't developed AI specific risk management framework. So my friendly edit was to change it to say has developed risk management frameworks for agencies that can be utilized in implementation of AI systems. When you look at the references below, there are privacy frameworks that can be leveraged for use of AI, but they are not specifically AI risk management. So instead of to utilize, I was going to say can be utilized. And then instead of a risk management frameworks, I think there are a couple of them referenced, so it should be risk management frameworks.
Mark, can you try to get those on the screen for us?
Sure. Elham, I'm wondering, would that change just require rejecting all of the changes proposed by Jonathan, Steph, and OMB if we do that and revert to what was there before? That sounds like what you're proposing.
No, I think it's good to add them in the footnote, but instead of saying the sentence as it's written now implies that there were a risk management framework developed by OMB and NIST for use by agencies' implementation of AI. Such a thing doesn't exist, but there are risk management frameworks, and in this particular case for privacy risk assessment that can be used by agencies in implementation of AI. Yeah. Yes.
Okay.
Jonathan, are you okay with that?
I'm trying to read it. Actually.
I think it looks good.
Yep.
For what
Does
it's-
anybody have any objections to this as revised? That's fine to me as it appears in the text. I'm wondering about the footnote where the red line proposal is to strike out some additional language after C, but I wonder if there is no established framework for this, whether it would be better for that to read something like C generally, to give another indication that there may not be an established framework. But again, I'm not close to AI, and I'd appreciate the views of people who are close to it.
I think a footnote is good. It's just example of some of those frameworks developed by NIST or OMB that can be leveraged in implementation of AI for the privacy concerns.
Keep the CEG, C for example, and then list them all.
Yeah, as it is right now, NIST SB 837 is cited, and OMB A130 and NIST privacy framework. So I think it's good.
Carrie's solution, I think, is a good one.
And then I don't, do you need the C also anymore? Or is that just another one of the examples? So they're basically 3 examples.
Oh, I see what you say. Right, you can strike C and just start by EG. Yeah, I got it.
Yeah, or the C also down in the middle of it. Yeah, there we go. Mm-hmm.
Thank you.
All right. Does anybody have any objections to the text of the paragraph or the footnote as they currently stand?
Well, this is Don. I have a suggestion for clarification, where we say that these privacy programs can be used by agencies. Perhaps we should say something like can be modified for use, so that we're not misperceived as saying they can be, taken literally and applied to AI, unless that's what we're saying, which I don't think is the case.
Can be adapted for use or modified for use.
And Ellen, you may want to speak on whether of the examples, any one is more relevant than the others, but otherwise I would go in reverse chronological order. Seems odd to me to have the most recent one last. So I would put that one first, and then also the 2 NISTs are together, and then the OMB. But you may know more if one is more relevant than others.
Actually, that would also help with the relevance, because I think the privacy framework is most relevant. And in terms of the word, it can be utilized, can be adopted, it can be modified. I don't think we want, I think modified is the wrong word here, because the framework is not going to be modified. These frameworks are generalizable and adoptable enough. So I vote for the current language that can be used.
I think, pardon me, but I think the language that's currently before us is carries that can be adapted for use. So maybe I wonder if that might be acceptable to you.
Yeah, that's good. We can work with it, yes.
As the sentence has been revised, does anybody have any objections to our adoption of the language in this paragraph?
Sorry, can I have another change? It says at the end of the sentence, it says in implementing AI systems, but it is for both implementation and deployment. So in implementing and deployment of AI system, it's not, they're useful for when you design. Yeah, thank you.
Same question.
Should it be designing and deploying AI systems?
That's even better. And get rid of implement. Yep.
I repeat myself, as now appearing on screen, does anybody have any objections to the adoption of this paragraph? Hearing no objections, these changes are deemed adopted, and let's keep moving. Let's get into number 7, security. There are no red lines on this, but I wonder if anybody has a comment on this that they wish to make.
I do have a comment, a suggestion to add a similar sentence to the one that's at the end of the privacy, to reference some of the risk management approaches that has been there, and reference NIST cybersecurity framework. The point and idea here is that there are already guidance and frameworks available for agency to leverage, and they don't need to start from scratch if they are worried about privacy and security.
How would we break that concept down into text?
We can repeat, one way is repeat the same sentence at the end of the privacy and says, or I can put something on the chat quickly, that current standards and frameworks can be leveraged for assessing AI security. I'll put some suggestion in text in a minute.
Could that be addressed through just a footnote? Is that what we're thinking about? Or does it need a new sentence?
I was thinking the same style as the privacy section, a sentence in the section that talks about frameworks that are already exist, and then a footnote with examples of those frameworks. But it can be just a footnote. I'll be okay with that too.
But if so, then in privacy, it should probably be a footnote. It seems odd not to have it be parallel, right?
Right,
So
in terms
suggesting
of like,
something of not equal importance.
One value of the footnote approach might be that these frameworks themselves may change. There may be new frameworks that emerge. So the statement, the ACUS statement, presumably will have a longer, or may have a longer life than some of the specific frameworks that exist today.
So does somebody have a specific text to propose?
I'm working on it. I'll be quick.
Okay. While you're working on that, if I could interrupt to say, Don Elliott had sent in a chat request to speak. Don, I'm sorry I didn't see that in time. Is there something that you'd still like to say?
No, I made the point.
Okay, good. Would it make sense to give you some time to work on that and have us go on to Section 8 on decisional authority and then loop back? I'm sorry, can't.
Yes, please.
Yes.
Thank you.
Okay, good. We'll go on to 8, decisional authority, because we do have something in the first paragraph here, the one that now begins on lines 146. The council has proposed that, Mark, could you go down a sentence? The action starts there with the redlining. The council has proposed that we consider striking this sentence and combining this paragraph with the one that follows. And I think there's a preference for use of the word devolve rather than delegate in the one that now begins on 150. And I'll ask the members of the committee if they have any objections to carrying out what the council has suggested as the appropriate approach here.
John, what is it? Wasn't that already voted on, the council's revisions, or no?
I would say that that's true for all aspects of it, except perhaps combining the two of them. But I wouldn't want to second guess the council in this one. It seems to me that the only one of these that's at all significant is changing delegate to devolve. The others, I think, have happened by virtue of that prior vote. And I ask anybody if they have any objection to striking delegate and or doesn't to using the word devolve. Actually, Mark, I may have that backward. You were at the council meeting.
Well, it's not a council change either. You'll note that's from Anthony.
Sorry, my mistake.
And it's the other way around. It's replacing devolve with delegate.
Right, which I would object to. I prefer delegate to, or I prefer devolve to delegate. I think there's good reasons to stick with that.
Why would we stick to delegate? What are the reasons for that?
No, stick to devolve rather than delegate.
Yes, you can tell I'm messed up on this one.
I don't have strong views for delegate, so I'm happy to go with the consensus on the group on that one.
All right, well, I think we can save time on this one. As we're still working on chapter 7, we can ask, since we've already adapted the what the council requested, does anybody have any objection to anything in subject matter 8 as revised?
I do think it's important to clarify that you are deleting that sentence that the council recommended. The earlier vote on the council recommendations did not have that sentence deleted. It just had a comment saying to consider it. So if there's no objections to deleting it now, then I think it can be duly considered, accepted.
You make a good point, Carrie. As just restated by Carrie, does it, with the explicit inclusion of this sentence,
deletion of the sentence, right?
Deletion of the sentence. Does anybody have an objection?
And then I think, yeah, that's great, Mark. Great.
So, hearing no objections, I consider the changes adopted, and I'm thrilled to be exiting section 8 since I made such a hash of it. Well, now, are we ready to come back to 7, or should we continue moving on?
I put a suggested text here, and then I expanded to also add voluntary consensus standard. I read it for everybody. Agencies shall continue to use, or maybe I should have said agencies should use voluntary consensus standards developed with industry participation when available, and existing frameworks, for example, those developed by National Scope Standards and Technology in designing and deploying AI systems. And then a footnote 2, and I would a footnote to cybersecurity framework, and I would add references to the footnote here in a second.
How
with Mark's comment in the comments that we shouldn't refer specifically to NIST in the text. We can do that as a C, for example. You know, those developed by NIST, et cetera, and then give specific examples and even links if we want. But I think we should be general in the text.
That makes good sense to me.
And I think we should do so in the privacy section as well. So Karen made this point earlier, but I think that should be consistent in privacy and security. So the language in the text should be general on the aspiration this will have a long, long shelf life, and then footnotes each.
Completely agree. I cut and paste from this privacy section. Harmonization is good and making it general is good too. Thank you. And I need to give you a document. Well, we have it's being downloaded. Too many windows open. Sorry, now that we are, I think we can just say agencies should consider using voluntary consensus standards and frameworks developed by, and then make it by industry participation.
Good. How do people feel about the sentences added? I'll ask for comment on that. We still have a footnote that we're going to need to drop here.
And I wonder if you want to consider that sentence preceding the citation in the footnote, or do you want to keep the sentence in the statement itself, in the text portion of the statement?
Right. Right. The phrase voluntary consensus based was intended to address the point about open multi-stakeholder processes, but I believe open multi-stakeholder processes might be even more clear. Voluntary consensus based standard is the term used in OMB A19 circular.
It's maybe instead of developed with industry participation, developed through open multi-stakeholder processes.
Excellent.
That's just, Deirdre gets credit for that.
So how does this sentence as revised strike people? Or are there any other comments on additional changes that might be made?
This is Elham again. Agencies should consider using relevant voluntary consensus-based standard.
And I think also it's the frameworks and standards that are where available, not the open multi-stakeholder processes that were available. You know, maybe you should say, should consider, you know, where an agency should consider where available, or consider using where available, excuse me.
I think you can keep out the where available, right? You can't consider using something that's not there. I would just drop it.
Right, right.
Yep.
Yeah, that works tighter.
Yep.
Yep.
All right, I think we may have it here. Anybody have further suggestions or objections to the sentence?
You want to just add a footnote there and then bracket what will be in the footnote? Or for a CEG footnote? Or not?
Yeah, 1 second. Sorry, I'm just trying to process a couple of comments that just came in, including one from Deirdre that I think the committee probably has to approve before I add it or don't add it.
Mm-hmm.
I
sorry, Mark,
think the additional requiring is good.
Right, I think adding the footnote this way is within the ambit of the authority of a committee on style, so this will save us some time. We've got a little less than 20 minutes left, and we have one major, the oversight section to go through, although most of the changes there strike me as pretty basic. There's at least one, though, that's an issue. And then we get to the vote.
Can before you leave it, John, I mean, this sentence, the ending now of 145 and 146 seems odd to me, that the multi-stakeholder processes are in designing and deploying AI systems. Why not? I mean, everything is really relevant. It's relevant voluntary. I don't know that you need in designing and deploying AI systems at all.
Or that could also go to the start of the sentence in designing. And
yeah, that's right. That if you need it, that would be the place to put it.
And Mark, just a quick comment. Did you make a similar, are we doing a similar thing in the privacy, namely the general statement followed by a footnote?
I made a note to myself on paper here. I can make it in the document to memorialize it for everyone if you'd like.
So it would be something like agencies should consider using relevant risk management frameworks in that context there, right? That have been
Use
developed
relevant
through
privacy risk management. Yeah.
Yeah. Something along those lines.
Right. Do we have any objections to the text and or the footnote with the being developed along the lines that's indicated in Mark's comment? One last chance before we leave the section. Going once, going twice. Any further comments? Hearing no further comments, I consider these changes to have been adopted by the committee. So let's move quickly to topic 9, our last full topic. Are you working on something, Mark, or is this going too fast for you, or are you up
No,
to speed with?
this is great. Let's go to 9.
All right. One minor change in the first paragraph, lines 170, 175. Any objections? Actually, I'm wondering if likely is a little bit too firm, but the people who are close to AI will understand this much better than I. And I also have a linguistic question as to whether it should be the better they are likely to fare, whether the focus is on the mechanisms or on the agency.
It definitely should be they. And it could be either are likely to fare, or you could say they may fare.
Right, as Mark has put it on the screen, does anybody have objections to this red line of the short paragraph?
Carrie, can I just ask for some clarification? The edit that you've proposed suggests changing it to they suggests that it's the internal oversight mechanisms that will go through the ringer of external oversight. And I'm not an expert, but I just want to make sure that that's what happens and that it's not the agency and its processes more generally that are subject to external oversight.
Yeah, I would say maybe change it to the agency may fare or something. And again, if we're doing
go ahead.
the agency systems, you could just change it to the agency's systems.
So I have a slightly more radical suggestion. I would drop that sentence. I don't think it's appropriate for us to be opining about, about the likelihood of success when we're thinking about all sorts of things like courts, et cetera. I'm not sure why what work that sentence is doing, but I would drop it.
Yeah, I think that's dropping it's a good idea. And clean.
Keeping it shorter is fine with me.
So what is the sentiment of the committee for adopting this paragraph after removing the sentence that begins on 173 and extends to 174? Is that acceptable, or are there objections?
I think Deirdre thinks there's value, I'm reading in the chat, to having the sentence in. I
think it's useful to say that internal processes can be useful given the reality of external review. But I agree with Kathy that I don't think this sentence, the opining, wasn't particularly useful.
And with the prior sentence.
The prior sentence does it, Deirdre. Yeah.
So with that clarification, any further discussion or objections to this paragraph? Once again, in the interest of time, then I'll consider the changes adopted. And let's move on to the next long paragraph, starting at 176 to 189, and ask if there are any objections to the red lines.
I don't have an objection to the red line, but I would like to suggest an addition on line 177 after inspectors general, comma, I would add external agency ombuds. We've just done an recommendation about federal agency ombuds, and they would certainly play a role. And some of the ombuds, for example, the Citizenship and Immigration Services ombuds doesn't report to CIS, but reports to DHS. So it has oversight, but it of CIS, but it's outside of CIS proper.
Any objections to adding external agency ombuds to the list of entities that might be overseeing AI systems?
Do we need the external there? That seems to suggest someone who sits outside government in a potentially unuseful way. I hear you about the DHS example, but I wonder if that's just extra and confusing.
Now, later on, I'm going to make a recommendation about in another paragraph about internal agency ombuds, and I use the word agency to indicate that that they were related to the agency. They weren't a non-federal, a non-governmental ombuds. And I think that's consistent with the report, the recommendations in the report that ACUS studied and adopted last year, a year and a half ago, I can't remember, that we had a difference between external and internal agency ombuds.
So now that you've had a chance to foreshadow the forthcoming amendment, let's try to reach it in logical order. And I'll go back to, as the paragraph now stands on the screen, does anybody have any objections to it?
If I might just add, all the people in this list are all external to the agency. And I just thought that we needed to make that clear what kinds of ombuds we were referencing.
John, if the committee is generally in agreement with the concept of external, could this be just remitted to the Committee on Style to track the prior ACUS recommendation in defining external ombuds?
Good point. So with Matt's suggestion, are there any objections, or can we adopt this and move on? Hearing no objections, I deem this adopted and we're moving on. We're now at the paragraph that begins on line 191, goes to 195.
And so here's where I would say, and I can't see the line, but there's a list of legal, policy, financial. This is where I would have put internal agency ombuds and advocates.
So you're on line 195?
Yeah, that's the one. I'm working off a different.
Yeah, there's a couple lines different. How does this work?
You can refer that to the Committee on Style again, too, for how they want to frame that. But
with the proposed addition, does anyone wish to be heard, and are there any objections?
I would just note two things. One, now it kind of says it's internal agency, so it might be some just grammatical issues with that, but I think it's fine the way it is. On the previous edition from DOJ, which is on the page above this, I just wanted to flag that given our change to regular monitoring, we might want to tweak ongoing oversight, or either just say regular oversight, or do we want to change both uses of oversight in the sentence to monitoring? I have no strong views, and I think oversight is fine. It just regular oversight should be better than ongoing, given our prior changes.
Does anyone have an objection to insertion of regular as opposed to ongoing? Hearing no objection, I'll deem that adopted. Now at the end of this paragraph, is there any objection to ombuds and advocates being added? Hearing no objections, that's deemed adopted as well. I think we can take the The next, let's see, where are we here? I think we can take the next three paragraphs from lines 198 through 214, will it be? And ask, two of these have no objections to them because there are no red lines. The red lines appear in the first of the three paragraphs, but I'd like to move the adoption of all three of these. But first I need to check to see if there are any objections to the red lines at 198 to 201.
I guess I'd like to hear maybe more about the for efficacy and ethicality. Ethicality just strikes me as a strange term to be inserting here. And then, so I would just do a full stop and not. So I guess I'm offering an objection to the insertion.
I concur. I would leave it out. It opens a huge can of worms that we haven't used that term throughout the document nor defined it.
Yeah, I have no strong objections to that. That was something one of our components suggested, but I think it's fine to leave it out. Just don't tell them I said that.
So with that modification, any objections to the adoption of these three paragraphs? Hearing no objections, they're deemed adopted. So we're in the last two lines of the document. My comment here is similar to the one that I had before at the beginning when we listed the 9 categories to be discussed. Typically, ACUS does not end with a conclusory sentence like this. It's something that's more commonly found in brief writing, but ACUS doesn't do it. So I propose that this be deleted. It's just not in the ACUS style. Anyone wish to be heard? We have a couple of agrees that are up on the chat feature, but I wonder if there are any objections to its deletion. And hearing no objections, it's deleted, and the changes are adopted. We've now reached the end of the text. We've gone through this paragraph by paragraph. I appreciate all the hard work that went into preparing this statement by all the people who were on this call and others who couldn't make it today, and greatly appreciate everybody coming up with comments in this last crazy period. I think we have a text that that we can now vote on. And I'll turn it over to the people to run the vote to what needs to be done at this point to make certain that we have something here that we can forward to the council.
John, you can proceed however you wish. You could sort of do it by unanimous consent. I think if Sean is okay with that, can we do this by, so Sean is giving us a thumbs up. The only important thing to keep in mind is that only committee members can vote. And then if I may just have 30 seconds of the committee's time when you're done, I'd appreciate it.
All right. That sounds like a good way to do. Only members of the committee can vote, and I'll ask that this be adopted by acclamation. Are there any any objections to having this done by unanimous consent? Hearing no objections, I declare that the statement as it's currently formulated has been approved by the committee. Thank you very much for your attention and participation in this extended project. Matt, back to you.
Well, John, bravo for getting this done. This may be much more than you signed on for when you came out of retirement, so to speak, to be the committee chair here. And I think I can thank you on behalf of the entire committee, and I can certainly thank you on behalf of the conference for chairing this committee and spending an enormous amount of time and lending your real considerable talents to this project. So thank you. I would also, we will find an appropriate way to thank the members of the committee and our special invitees at the plenary session. We'll put your names up on the screen and we'll thank you in our formal public remarks or my formal public remarks. But a thank you now. I'd especially like to thank also our consultants here, Carrie, Dan, Kathy, I guess Tino, and of course Carrie. Whom have I forgotten here on the consultant end? Is that everyone?
Just little me, David Engstrom.
David Engstrom, and I'm looking right at you as I'm reading, as I'm mentioning the others' names. Thank you, David. And you know what, David, actually, I should just say this. David, in some way, maybe unwittingly initiated this project during a conversation with Reeve and me in ACUS's office several years ago. So thank you so much, David, for all you've done here. And the last thing, John, if I may, have we identified and thank the members of the Committee on Style?
Can we just thank
Mark,
that, Mark?
You know, it's one thing to participate in the committee meetings, and that is indeed a big thing. I don't mean to lessen that, but it's quite another thing to spend 5, 6, 7, 8 hours over your Thanksgiving break working with Mark to make stylistic edits. And so I think it would be nice, Mark, if you could just identify the members of the Committee on Style who worked so hard on that. And I guess our consultants were de facto members of the Committee on Style, including Carrie, and they too should be thanked for their Thanksgiving work. And most importantly, Mark, before I let you read the names off, I'd like to extend our profound thanks to you. I know you spent many, many late nights or early mornings working on this, assimilating comments, and I think everybody on the committee would agree that you did an outstanding job, and you also put up with Reeve and me, which is not nothing. So thank you so much.
Thanks, Matt. That's very kind. You guys made this immensely easier by your willingness to help. So in addition to the consultants who, as Matt said, did get conscripted into being members of the Committee on Style, whether they wanted it or not, the Committee on Style was Mike Livermore, Eloise Pasikoff, John Cooney, and then Toby Dorsey, all of whom were exceedingly gracious with their time. And I personally very much appreciated your willingness to put up with the late night emails and the Thanksgiving weekend calls and, threads. So thank you all very much for that. I think the statement came out really well.
And we will hold this project up among many when we make our pitches on Capitol Hill as an example of how much private sector time is donated to the administrative conference, and not just those of you who have very high hourly rates.
Thank you very much, Matt. My father ran Andrew Jackson's plantation and ran the presidential papers there. And as a birthday present, once his workers made for me a copy of the gavel that Jackson used as a justice of the peace in Tennessee in the 1820s. So whenever I chair something like this and it's time to adjourn it, I use Jackson's gavel, and I want to thank you all for your participation. This committee is adjourned.
Thanks, guys.
Thank you, John, and thank you, Mark.
Thanks all.